how a bill becomes a law in Nigeria, and how the 2025 Tax Act became a scam. Let us start with the law, not press releases, not presidential explanations, not media spin. The Constitution of the Federal Republic of Nigeria. Under Section 4, Subsection 1 of the Nigerian Constitution, legislative power belongs to the National Assembly, not the President, not the Presidency, the National Assembly. This means the House of Representatives and the Senate must pass the bill. Only then is it sent to the President. This entire process is governed by Section 58 of the Nigerian Constitution. Here is how a bill is supposed to become law. First, a bill is introduced in either chamber of the National Assembly, the House of Representatives, or the Senate. This is called the first reading. There is no debate, no argument, this formal introduction. Section 58, Subsection 1. Step 2. Second reading. This is where lawmakers debate the principles of the bill. They argue its purpose. They argue its impact. They vote. If it passes, it proceeds. This forms part of the passage process required under Section 58, Subsection 2. Step 3. Committee stage. This happens at the National Assembly. Public hearings are held. Citizens, experts, stakeholders are invited. The bill is reviewed clause by clause. Amendments are made. A committee report is produced. These powers flow from the National Assembly's legislative authority under Section 4 and its internal procedures recognized by Section 60 of the Constitution. Step 4. Third reading. Final consideration. Final vote in that chamber of the National Assembly. This completes passage in that chamber under Section 58, Subsection 2. After this, the bill moves to the other chamber of the National Assembly. If it started in the House, it goes to the Senate. If it started in the Senate, it goes to the House. The entire legislative process repeats again. First reading, second reading, committee stage, third reading. The critical point. Now pay attention. This is where the Constitution becomes very strict. The two versions rule. If the version passed by the House of Representatives and the version passed by the Senate are not identical, the bill does not go to the President for assent. It cannot. The National Assembly then forms a conference committee. This is a joint committee of House and Senate members. Its function is harmonization, to compare both versions line by line, word for word, clause by clause, until one final harmonized text is agreed. This harmonization is constitutionally necessary to satisfy Section 58, Subsection 1 of the Constitution, which requires that both chambers pass the same bill. That harmonized bill is not law yet. That harmonized bill must return to the House of Representatives. The House votes again. That same harmonized bill must return to the Senate. The Senate votes again. Only after both chambers of the National Assembly pass the exact same harmonized text, word for word, is the bill enrolled. Enrollment means the National Assembly produces one final official document. It is certified as the exact text passed by both the House and the Senate. The enrolled bill is authenticated by the Clerk of the National Assembly, under the Assembly's procedural powers granted by Section 60 of the Constitution. This document is the only version that can be sent to the President. Once done, the enrolled copy is officially transmitted to the President. This entire process is governed by Section 58, Subsection 3 of the Nigerian Constitution. At this point, the Constitution gives the President exactly two options: sign the enrolled bill exactly as passed by the National Assembly, refuse assent and return it to the National Assembly. Section 58, Subsection 4. If the President refuses assent, the National Assembly can still pass the bill again by a 2/3 majority. Section 58, Subsection 5. There is no third option. No editing power, no rewriting power, no interpretation power. The President is not a legislator. Legally, a law is defined by what the National Assembly passes, not by what the President prefers. Again, Sections 4 and 58 of the 1999 Constitution. Now here is what happened with the 2025 Tax Act. Bola Tinubu signed a document that is not the enrolled bill, despite a documented chain of custody from the National Assembly to his desk. He ignored the version that was sent and received, substituted a different text, and signed that instead. That is not a mistake. That is not a clerical error. Under Nigerian constitutional law, the 2025 Tax Act he signed has no legal validity, irrespective of what his surrogates want the public to believe. This is the direct consequence of Sections 4 and 58 of the Nigerian Constitution. When caught, instead of acknowledging the violation, the Nigerian presidency chose gaslighting as the way forward. Committees were set up in Nigeria. Spokespeople were deployed. Media surrogates were unleashed. Some officials even admitted publicly, yes, the President did not sign the enrolled copy, the correct bill, and yet Nigerians are being told to accept it anyway. As stated numerous times already, under Section 4, legislative power belongs to the National Assembly. Under Section 5, executive power belongs to the President. When the executive rewrites a bill, Nigeria's separation of powers collapses. If the President can change enrolled copies of bills at whim, nullifying what was passed, then every vote in the National Assembly becomes decoration. That is not democracy. That is forged law backed by state power. If this stands, bills no longer become laws. They are simply window dressing for whatever the presidency decides to make a law. This is Systems Under Review. Thanks for watching. Please subscribe, like, and share.